This is Dave Stouse. I'm a partner at Husch Blackwell and a member of the firm's privacy and cybersecurity team. I'd like to thank you for joining us here today, spending a little bit of time of your day with us as we take you through what you need to know about the 2024-2025 compliance deadlines. This is a slide that shows you the speakers you're going to hear from today. Thankfully, you won't have to hear from me the entire time. You get to hear from the much more intelligent and eloquent Shelby and TK during the presentation. What I will say is those QR codes that you see at the bottom of our profiles there, our pictures, I should say, will take you to our LinkedIn pages. If this webinar is of interest to you, you may want to friend or follow us. That way you can stay up to date in between webinars. A couple of housekeeping items before we start today. If you have questions, please feel free to ask them. We'll do our best to answer them during the presentation, but we tend to jam a lot into these webinars. If you've attended one before, you know that. We only have an hour, and inevitably I talk way too long during the presentation, and we run out of time at the end. But if you have a question, let us know. And then, if you don't get an answer and you want one, you can always ping us on email. We'll do our best to respond. The second thing we always get asked a lot about is CLE credits. It's my understanding that there is a button somewhere available on 24 that gives you access to the CLE credits that you need. Again, if you have more questions about that one, you can always drop me an email. Usually I get like 2 or 3 emails after a webinar asking for CLE information. Don't feel bashful. Always happy to help you guys out. Okay. So if you've attended one of our prior webinars, you probably know that we always start with a roadmap. So I typically have a slide that says literally roadmap on it, and then it's got a bunch of numbers there about what we're going to talk about. This is our roadmap today. It's pretty small, but there's the QR code there, and you can use it to kind of grab the graphic. You may have seen a prior version of this either on LinkedIn, or you may have seen it on our blog Bite Back. This is new, it's updated. We're releasing it today for the first time. In fact, we just updated this morning. We found a tweak in it that needed to be updated. The Utah Social Media Act has been extended to October 1st. So we updated that this morning, just going through our quality control checks. But this is how we're going to approach today's webinar. And the idea behind this webinar was we kept on having clients ask us and coming to us this year and saying, what do we need to do, right? What do we need to do in 2024 to comply with all these laws? You've done webinars, Dave. You've put articles out. Your team is great. They're putting out a ton of content on all these things, and all these things have passed. But what's the project plan, right? How do we get across the finish line here? And I think, one of the challenges we face in privacy law right now is these laws are coming on at a really rapidly effective rate. Gone are the days where we just had to drive compliance for CCPA, like a January 1st deadline. And now we're trying to drive compliance against a calendar that's filled with deadlines. And you see that here, and that's what this timeline is showing you. So anyway, our goal today, and the roadmap that I'm going to suggest that we're going to follow here today, is to take you through these monthly deadlines and help you to create essentially a project plan. We'll have checklists, we will have nuances between these laws, and then we will have some takeaways and those types of things that you guys can take back to your organizations to hopefully drive compliance. So one last thing before I turn it over to Shelby, start talking about February of 2024, which is now. Not every law we discussed today is going to be applicable to your organization. We're going to talk about consumer privacy laws. We're going to talk about children's, consumer health data privacy laws, data broker laws. We're going to move quickly through these laws. So if you don't like the substance, just hang on for a couple minutes and we'll be on to something else. But I also think it's important that you hear about these laws because it is equally important for you to figure out what does not apply to you as what does. And I think that's part of sort of the chaos we see is we see a lot of confusion about what does or does not apply to organizations. So hopefully what we go through today can help you get across the finish line. Okay, it's enough of me. Let me turn it over to Shelby, who's going to talk to you about February 2024.
Hi, everyone. This is Shelby Dolan. Great to be here again, and I'm ready to dive right in here, starting with February 2024, which is now. And it's crazy that we only have about a week left, but these are the obligations you need to be considering. So first up, we have the CCPA regulations that are now effective. On February 9th, 2024, a 3-judge panel of the California Court of Appeals issued an order overruling a California trial court decision holding that the CCPA regulations approved back in March 2023 could be enforced immediately. So the trial court had originally held that these regulations could not be enforced until 1 year after approval. So instead of the end of March this year, all of the CCPA regulations are actually now enforceable. So it is important to note that this decision means any new regulations promulgated can be enforced once approved. So for reference, the California Privacy Protection Agency is currently working on 6 different sets of regulations, including cybersecurity audits, automated decision-making, risk assessments, revisions to the CCPA regulations, insurance, and data broker registry fees. So we can be on the lookout for those regulations. I do want to point out that although once promulgated, they can be enforced once approved. The agency does have the right to consider the amount of time between the effective date of regulations and any alleged violations when they're deciding whether to pursue an investigation. So there's still, there's potential for some wiggle room, but important to note that the CCPA regulations are now effective. So we do want to highlight a few considerations for these regulations. The first is CCPA's requirement to limit the processing of PI to what is necessary and proportionate to achieve the disclosed purposes. Businesses may process PI for other compatible purposes as long as those purposes are consistent with the reasonable expectations of the consumer. The CCPA requires the business to consider multiple factors when making this determination, including what does the relationship look like between the consumer and the business? What's the type, amount, and nature of the PI? What's the clarity of disclosures to consumers? If a consumer does not meet this analysis, if the purpose does not meet this analysis, then the business must obtain consent from the consumers for the additional purposes. So the takeaway here is that businesses' use of PI is going to be more limited to specific purposes now. It can't just be a laundry list of, we're going to use your PI for all of these purposes. So another obligation we want to note are the various updates to the disclosures in a privacy policy. These updates are pretty significant. They require businesses to disclose their practices regarding the processing of sensitive PI and the recognition of opt-out preference signals. So now would be a really good time to update your privacy policy if you haven't done so already, since this is in effect. So take a look there. Next on the list is opt-out signals. So the CCPA regulations require businesses to recognize the global privacy control signal. This signal is a type of opt-out preference signal that California residents can use on website browsers to automatically opt out of sales and targeted advertising. The CCPA regulations are really specific about recognizing this signal on both the browser device level and the account level, meaning that if a consumer visits a website with the signal turned on and is logged into their account, the business must recognize the signal for both that consumer's device and browser and that consumer's account. If a consumer then visits the same website but using a different device or browser and logs into their account, then the website cannot just take this as an opt into sales and targeted advertising because the opt-out signal is still associated with that account. So businesses that feature accounts really need to focus on operationalizing this requirement and recognizing the GPC signal on both browser and device level and account level. So like Dave mentioned, we're going to show you some checklists through each month. We love a good checklist here on the data privacy team. So here's one that we have put together for CCPA regulations. First is, have you updated your privacy policy and your employee privacy policy? Under the CCPA, businesses must update their policies annually. So take a look at those updated dates to determine that deadline. And even before the CCPA, we've always recommended an annual update. You know, keeping transparent with your privacy policies is really important. So take a look there. Are your websites providing opt-out links in recognizing the GPC signal? Just like I was just talking about, you need to make sure that your website is providing an opt-out link and recognizing the GPC signal, like I said. So lastly, are you providing a notice at collection? Meaning anytime you collect PI from a consumer, do you provide a notice that complies with the CCPA regulations? Whether you're collecting online or in person, you need to provide this notice. So here's our checklist here. I'm going to pass it over to TK to discuss another California law that goes into effect this month as well.
Thanks, Shelby. So switching gears to California data brokers, recent amendments to California's data broker registration statute per the California Delete Act shifted oversight authority and responsibility of the state's data broker registry from the Attorney General to the California Privacy Protection Agency as of January 1st. So California data brokers are now required to annually register with the agency by the 31st of January and pay the $400 registration fee. So if you happen to be a data broker in California and have yet to register with the agency, this is a friendly reminder to look into doing so, given that the registration deadline was the end of last month. And so data brokers should also consider whether they're subject to the new data broker law in Texas. And under Texas law, a data broker is defined as a business entity whose principal source of revenue is derived from the collecting, processing, or transferring of personal data that the entity did not directly collect from the individual linked or linkable to the data. This definition is both narrower and broader than other data broker laws in that it requires that the entity's principal source of revenue be derived from data brokering, but it expands the brokering activities beyond the typical selling or licensing of such data that we see in California and Vermont's data broker laws. So a Texas data broker's initial registration must be filed on or before March 1st of this year, along with paying the $300 registration fee. Texas also requires data brokers that maintain an internet website and or a mobile app to post a conspicuous notice on their respective website or mobile app containing applicable disclosure language that's provided by Texas in their data broker rules. The screenshot here is of the rules required language for websites. The language for mobile apps simply replaces website with mobile application. Data brokers should also prioritize whether they need to register under Oregon's new data broker law, which defines data broker as a business entity that collects and sells or licenses brokered personal data to another person. As of January 1st of this year, data brokers operating in Oregon are required to register with the Oregon Division of Financial Regulation to legally collect, sell, or license data from Oregon consumers. And to help facilitate the division's processing of your registration, you should ensure that you have an active registration to do business in Oregon with the Oregon Secretary of State before submitting your data broker registration application, just to help, facilitate that process. As for the application, you will need to apply through the state's website and pay the $600 registration fee. And continuing violations, such as a failure to register as a data broker, may result in civil penalties of $500 for each day the violation continues. And the total amount of penalties that the division may impose on a data broker cannot exceed $10,000 during any calendar year. So for more information, and if you happen to need to register as a data broker, we have QR codes here to each state's data broker registration page. And I'll now pass it off to Dave for March 2024.
Yeah, thanks, DK. And just there was one question that came in, which was if you host a loyalty program on behalf of another company to make you a data broker. I think, I hate to give you the lawyer answer to every question, which is, it depends, but in some respects it does. We've looked at those types of situations. If you're a processor, then you're okay. But essentially, and the definitions of data broker do differ between the statutes, but essentially, if you don't have a direct relationship with the consumer and you're selling that data, then you get into data broker land. But if you're set up as a processor of the loyalty program, then, very, very broadly, generally speaking, would not be. But again, the devil is kind of in the details there. Great question. Okay, so before you showed up today, you may not have known that March is Consumer Health Data Privacy Month. At least that's what it's stacking up to be this year. The first one and to really talk about is Washington My Health, My Data Act. And you will note that the title My Health, My Data has been struck through. That is not a mistake. That is supposed to be done to get the point across that Washington is much broader than its name suggests. I think they really did a disservice with this law by calling it My Health, My Data, because it is, and I'll show you in a second, it is broader. And to the point, when Shelby and I were sort of starting to conceptualize this webinar, we were thinking of just doing a My Health, My Data webinar. And I thought, well, nobody's going to show up because everybody's going to say that they don't use health data, right? But you're here, right? And so we can kind of go through and we can show to you just how broad this is, and really the tail wagging the dog on this law as well, and why so many people in my position are talking a lot about it, is that first part there, enforcement, the prior right of action. Notwithstanding BIPA, this bell really hadn't been rung in a state before. Especially in a suggest a broad consumer privacy bill, and so this is transformative, or at least we think it will be. And who knows? Sitting here next year, maybe I'll have a different opinion here. But I think a lot of us are thinking that this is problematic and really should be driving compliance and stuff that you think about. What I will say on the prior right of action is we wrote an extensive article on the blog back in the day. It was probably 6-8 months ago. Dustin Taylor and a couple other of us wrote an article on it. So if you really want to deep dive into prior right of action, it's there for you. And what I'll also say is that there are no statutory damages associated with My Health, My Data. So that's a big difference with BIPA as well. I want to be upfront, transparent with that. That's not to say there's not big risk here with the prior right of action. And it's broad. And so it's broad in a few ways that I really want to get across to you guys today. The first is its broad in applicability. There is no 100,000 consumer threshold, right? We've gotten really used to 100,000 consumer threshold for the consumer data privacy laws. That's not here with this law. It talks about regulated entities, and it also has limited exemptions in place as well. You won't find entity level exemptions in My Health, My Data. You'll find data level exemptions. It's also broad in the definition of consumer. Consumer is a state resident, which we're very familiar with, right? But it's also defined to be a person whose data is stored in Washington, right? So you can collect it out of state. And if you're storing it on Washington servers located in Washington, the law purports to attach it. I think there's probably going to be some constitutional arguments around those issues, but on its face, that's what it says. So it's not just a matter of where you collect it, it's also where you store it. And then we get really to, really the point to get across, right, is this broad scope of consumer health data. So it is the term personal data is functionally replaced with consumer health data. And as you see here, it is personal information that's linked or reasonably linkable to a consumer and that identifies their past, present, or future physical or mental health status, right? But look at that second bullet point. I really want to focus you in on that one. You do not, the regulated entity does not have to use it to identify health status. It's enough if it can be used to identify health status, right? So I don't have to be using this information to actually deduce your past, present, or future physical or mental health status. If I can do that, then it's covered under the statute. And then the statute goes on and it gives 13 examples, right? And it's examples, and I'll go over one in the next slide, one specific example I want to tease out. But it goes over 13 examples of what data that identifies a consumer health service is, right? And one of those is healthcare services, and that's the last bullet point there, right? And healthcare services is defined as any service provided to a person to assess, measure, improve, or learn about a person's mental or physical health, right? As we have taken clients through these use cases, it is incredibly broad, this. And you start thinking about things that have really nothing to do with consumer health data that could be used to measure or it could be used to improve. I mean, think about like things like ergonomic desks, right, are used to improve a person's physical health, right? Do you think of that as health data? I don't think of that as health data. But like in the definition, so it really is a matter of taking this and really kind of driving down into the weeds about what it is that you do and whether it could be covered under this one. And keep in mind as well that this is a prior right of action. So it's not a regulator on the other side who is, potentially reasonable judgment. This is, plaintiff's attorney who can file a lawsuit and try to get a settlement out of people. That's why we are so standing up and talking about this one, right? I also say as well, it only applies to consumers, right? It doesn't apply to employees, so there is that limitation here. Okay. So next slide. I mentioned before that there's these 13 examples, right? And one of those examples of what constitutes consumer health data is biometric data, right? It has, and I want to make sure I get this across, My Health, My Data has freestanding applicability to biometric data, right? Biometric data is listed as an element of consumer health data, okay? In biometric data, the definition here is very broad. If we've looked at the definitions of biometric data that have come out of things like Virginia or Connecticut, and Shelby will talk about Oregon in a little while, which has a unique definition. But there, again, we get this concept, this distinction, right, between am I using it to identify an individual or is it enough that I'm collecting it, right? And Washington has been broader, and they have said it's enough. It's enough if it's collected, right? So if I collect, and that's why that word can is italicized and bolded, right? If you collect an identifier template, if you collect these things here, this iris, retina, fingerprint, et cetera, from which an identifier template can be extracted. It doesn't say that you are extracting it. It says that you can be extracted. So think about voice recordings. Think about like call recordings, those types of things, right? From which an identifier template can be extracted. And then the keystroke patterns as well. It really creates, again, I think you can see, hopefully you can see how this My Health, My Data name is really a misnomer on this statute. And it really does a lot of injustice, to entities that are trying to drive compliance. Okay, so if you're subject to it, what do you need to do? Well, there's a rub too. And where I'll really draw your attention to is the first two on here initially, right? So the collection and sharing of consumer health data. If you want to collect or share consumer health data, you've got two options: consent, or it's necessary to provide the product or service. That's it. Those are your two options, right? If you want to sell consumer health data, it requires a valid authorization, which there's a lot of requirements around what you need to do to obtain a valid authorization, which is functionally reads like it's a written signature type of authorization. Very onerous to receive. Sell is defined similar to the way that sell is defined in the California Consumer Privacy Act, okay? And what do we know? We know from the Sephora enforcement action, we know that tracking technologies can be part of the definition of sale, right? And so if that is the case, you connect all these dots and you have tracking technologies that are part of sale, how can you obtain a valid authorization to be able to engage in tracking technologies? These are the things, these are the difficult aspects of My Health, My Data right now that are really vexing clients out there, right? And again, it's a matter of trying to look at it and say whether this is something that could be used to infer health data, right? And I'll give you just one example here, because maybe two that I think is relevant. During the lawmaking process last year, they have committee hearings. Lobbyists came in and said, my concern is that, say you went into a grocery store and you bought ginger, right? And ginger could be a home remedy for nausea if you're pregnant, right? Is that considered to be consumer health data? Because it could show that a person is pregnant, right? Another example is there was an amendment that was run that would carve out things like clothing from the definition of consumer health data. The whole idea being, well, hey, this really should be narrow. We should narrow this down, guys. We should exclude things. That amendment didn't pass, right? And so again, I think what you see is, and I don't mean to seem alarmist on all these things, it sort of is what it is, and we'll see how this plays out. But I do want to just kind of relate to you guys, like just how broad that this could potentially be once the prior right of action goes into effect. Okay, so the Attorney General also has coextensive enforcement authority with the prior right of action. And the Attorney General's office has issued guidance. It's issued it originally, now it updated it as well. The QR code that's on the bottom right of your screen, hopefully, will take you to the AG guidance, to the webpage of the AG guidance. Three things that I wanted to just tease out for you guys here, and obviously feel free to dig in to the other stuff. Let's start with the second one, just take it out of order, and to really tease out what I think is a big deal, separate privacy policy. So this was a recent addition to the guidance. You will need to have a separate consumer health privacy policy, right? You can't take this and push it into your privacy policy, your existing privacy policy. You're gonna have to have a separate privacy policy. And if you look at it, it says that privacy policy may not contain additional information not required under the My Health, My Data Act, right? So really, it creates these challenges about how to draft these privacy policies, and the statute has specific requirements about what need to be in those privacy policies. But listen, I tell you, we always say, like, have outward compliance, right? Like, make sure that it appears to the world that you have compliance in place. And this is going to be one of these things where I think that litigants are going to be looking at the end of March to see whether or not there is a My Health, My Data consumer data privacy policy, right? They also talk about the homepage. It has to be on the homepage. There's a definition of that, and it's very similar to the CCPA's. It's any internet, it's the introductory page of an internet website, anywhere where personal information is collected, and then it's got some language around mobile applications as well. The AG's guidance, the last one there, the scope of consumer health, they provide some guidance as to, like, I'm not sure it's helpful, to be blunt. I'm just not sure it's helpful. They basically said if you go buy toilet paper or deodorant, it's not consumer health data, but an app that tracks digestion or perspiration would be, right? The fact that they said buying toilet paper is not covered, I think kind of suggests to you just how broad the statute kind of maybe is. Like they had to provide guidance saying that toilet paper is not covered and deodorant is not covered by a My Health, My Data law, right? I think it's almost like you read into this a little bit and you say, like, my goodness, this is really something we need to pay attention to. Okay. Nevada. So let's talk about a little bit nicer situation. So last year, if you recall, if we were sitting here last March-ish, I think when these bills passed, Washington went first. Washington passed its law, and then Nevada with SB 370 was hot on its heels. But in the Nevada law, the business interests were able to really hem in a lot of what was going on with My Health, My Data, right? And so there is no private right of action in the Nevada law. Great. And also this definition of consumer data health, it has this requirement that it be used, right? That the regulated entity use it to identify past, present, or future health status, right? Is a huge, huge distinction between the Nevada law and the Washington law. There's others. There's some exemptions that are really, one in particular around a shopping exemption. I know we've talked with multiple clients about that exemption as well. That's kind of important to take into account. But, point is here, in March when you're doing this, looking and then also envisioning like that your consumer health privacy policy, if you're subject to it, should take into account not only Washington, but also Nevada as well, although the requirements are very similar if you're subject to both. Okay, checklist number 2. This is your March checklist. This one's easy because it's sort of like a gateway, right? So if the answer to number 1 is yes, then everything else flows. right? If you process consumer health data, then you've got to do all the other stuff, right? If the answer to processing consumer health data is no, then you don't have to do all the other stuff. So really the rub becomes, are you essentially subject to the laws, right? But things that you'll have to do is, again, that separate consumer health privacy policy. Now we know the AG's office has said as much. The cookie treatment, like thinking really hard through the cookie stuff, right, about the tracking technologies. I really should have said tracking technologies, not cookies. But looking, at those and seeing what they do and seeing whether you think there's a risk profile there. Consent or collection for sharing, do you need that consent? Are you relying upon the necessary to process? Do you have processor agreements in place, those types of things, and then the valid authorization. Great. Okay. So with that, I will now turn it over to Shelby to talk about July of 2024. Shelby, you're up.
Thanks, Dave. So diving into July 2024, it is going to potentially be a big month for compliance for many companies. So let's start with Oregon going into effect. Oregon applies to any person that conducts business in Oregon or provides products or services to Oregon residents, and during a calendar year, either processes the personal data of 1,000 or more consumers, or processes the personal data of 25,000 or more consumers and drives 25% of its revenue from selling personal data. So that's not really uncommon. We've seen that in other state privacy laws, but I just wanted to start with the threshold requirement for Oregon. Oregon follows the Washington Privacy Act model, but has a few nuances we want to walk through. One of the biggest changes is the response to access requests. All other laws require businesses to disclose a list of third parties to a data subject that submits an access request. Oregon requires businesses to disclose a list of specific third parties, meaning the actual companies that you are disclosing information to. So you can't just provide advertising networks. You would need to state maybe Google Analytics, Facebook. So you have to provide that specific list. So that's a big change there. Oregon also does not have the same type of exemptions that we see under other state privacy laws. For example, there is no HIPAA covered entity exemption, and there are limited financial institution entity level exemptions as well. So this law has a broader scope, and these types of companies really need to take a look here. As Dave mentioned earlier, Oregon has a definition of sensitive data where it treats biometric data a little bit differently. Unlike Connecticut and Colorado, Oregon's definition does not require businesses to use biometric data to identify an individual. The drafting comments provided that this was intentional because the legislators view biometric data as extremely sensitive data. So the trigger here is the collection of biometric data, not the use. However, it is important to note that with respect to photographs and video recordings, those do not need to be for identification purposes to be considered sensitive data. Those do need to be. Those do need to be for identification purposes. So photographs and video recordings have to be for identification purposes. All other biometric data does not. So legislators kind of made that distinction by commenting on the pervasiveness of photos, audio, and video when making this distinction. And then I also wanted to flag that Oregon's definition of sensitive data includes status as transgender or non-binary and national origin, which are two definitions that we usually don't see under sensitive data. Okay, so Oregon, similar to Connecticut, requires opt-in consent for any targeted advertising, sale of personal data, and profiling of children ages 13 to 15, where the business has actual knowledge or willfully disregards age. So we're seeing this requirement pop up more with states that are proposing children's privacy laws this year. So, keep an eye out for that. We already have it with Connecticut and now Oregon. So keep that in mind. Like Colorado, Oregon is going to apply to nonprofits. So one difference is that nonprofits will have an effective date an entire year later. So Oregon, although it goes into effect July 2024, won't apply to nonprofits until July 2025. So nonprofits, take a look at Colorado and Oregon requirements because those will apply. And then depending on what state laws your company is subject to, Oregon may require additional disclosures to your privacy policy. Many of the Washington Privacy Act variants require similar disclosures, but it's always a good idea to take a look at those disclosures again, maybe when you're doing an annual update. So that's what I have for Oregon, and I'm going to pass it over to TK to cover Texas.
Thanks, Shelby. So the Texas Data Privacy and Security Act also goes into effect on July 1, 2024. Like Oregon, this Texas law is based on the Washington Privacy Act model, but there are some notable differences from the other WPA variants. For instance, this law contains a unique applicability standard and applies only to entities that conduct business in Texas or produce products or services consumed by Texas residents, process or engage in the sale of personal data, and are not a small business as defined by the United States Small Business Administration. Similar to the CCPA in Colorado, Texas broadly defines the sale of personal data to include transfers of personal data for monetary or other valuable consideration. Also keep in mind that if you are a small business but otherwise satisfy the applicability thresholds, meaning you are conducting business in Texas and you're engaged in sales, you will still need to comply with the law's requirement to obtain consumer consent for the sale of sensitive personal data. Texas also contains unique disclosure requirements for entities that are selling sensitive personal data and or biometric data. If you're selling sensitive data, you're required to provide a specific notice that states, notice, we may sell your sensitive personal data. And similar with if you're engaged in the sale of biometric data, you'll have to provide this notice language to consumers, but have it tailored to biometric personal data. For example, notice we may sell your biometric personal data. And these notices need to be posted in the same location and in the same manner as your privacy policy. So now back to Shelby for Colorado.
Perfect, thanks TK. So the Colorado Privacy Act is similar to Oregon. It applies to any person that conducts business in Colorado or provides products or services to Colorado residents, and during a calendar year either processes that 100,000 or more consumers' personal data or processes the personal data of 25,000 or more for 25% of its revenue from selling personal data. So although Colorado went into effect back in July 2023, some of the obligations had delayed effective dates. So that's why we're bringing it back up now. Effective July 1st, 2024, companies must disclose in their privacy policy how they process requests through universal opt-out mechanisms. So we're kind of back on those mechanisms that you have to use that you have to recognize on your websites. The Colorado AG's office recently published its list of acceptable universal opt-out mechanisms, which only included recognition of the global privacy control signal. So like California and other state privacy laws, businesses must recognize the signal for Colorado residents too. The other obligation centers around how a business processes sensitive data. If a business processes sensitive data and did not obtain consent prior to July 1st, 2023, then if that business has continued to process sensitive data, then they must obtain consent by July 1st, 2024 to continue to process sensitive data. Otherwise, they do need to stop processing. So that is it for the delayed effective dates for Colorado, both the global privacy control signal and the processing of sensitive data. And I am going to pass it back to TK to finish compliance for July.
Thanks, Shelby. So if you're a data broker, subject to California's data broker law, by July 1, 2024, you must collect and report certain metrics in your website's privacy policy regarding the types of CCPA requests that you received during the previous calendar year. These metrics must include the number of requests that you received, complied with in whole or in part, and denied, including requests to delete personal information, requests to know or access personal information being collected, requests to know what information is being sold or shared and to whom, requests to opt out of sales or sharing, and requests to limit the use and disclosure of sensitive personal information. You also need to provide the median and the mean number of days that it took you to substantively respond to these requests. Yeah, so now to Dave to wrap up this section with a July 2024 checklist.
Yeah, thanks, TK. So I was just kind of looking at the questions that were coming in. There was a number of questions around the Oregon, which Shelby teased out to be this new wrinkle in Oregon with respect to providing the list of third parties. And so it's if you're looking at SB 619, it's in section 3, and it requires a consumer or allows a consumer to obtain from the controller. And I'll just read it to you so that hopefully it answers a number of the questions. It says, at the controller's option, a list of specific third parties other than natural persons to which the controller has disclosed, one, the consumer's data, or to any personal data. So the controller's option there is either provide a list of third parties that is disclosed the consumer's personal data to, or any personal data, right? So it is the controller's option on either one of those. At least that's how I read the or there. I'm sure maybe reasonable minds could differ, but that's at least my reading of it. And there was one question as well about responding to that, right? And how would you respond to it? I think something we've at least thought about internally is, if your answer is always going to be the same for everybody, right? And third parties really come up a lot with cookies as well, tracking technologies. If your answer is going to be the same as everyone, maybe you can leverage existing lists and direct people towards that. For example, please see our list here. Maybe that's a cookie disclosure list of third parties. Maybe you would add a few names to the list to a cookie policy or something along those lines. So as far as operationalizing that goes, I think that's at least the concepts we were thinking about, because it does at least provide that, any personal data. But I also can think that some companies would be very sensitive to maybe identifying all third parties here. So anyway, encourage you. It's interesting. There is a lot of interesting fallout from this Oregon, this wrinkle here. Delaware, which we'll talk about in a minute, goes back to categories, but it has a little wrinkle there as well. But yeah, I encourage you to take a look at the statute. And I say there's a question here about what state requires cookie policies. No state requires cookie policies here. Don't hear us to suggest otherwise. But when you go from sort of looking at the text of the statute to thinking through how would I operationalize that text, which is what we spend a lot of time doing, I would suggest to you to think about whether the use of a cookie policy could help you get across the finish line with respect to this Oregon requirement to disclose third parties. Hopefully I've connected the dots there for you guys. Okay, so going back to this July 2024 checklist, I've stolen some of my own thunder here. I think taking a look at web forms and responses is a big piece of the puzzle here. I know when we try to draft ours for clients, those are more general, right? But if you're dealing with states that have different exemptions in place and you're trying to have a one size fits all, Oregon's going to complicate that in particular with what I just said with around the list of category or the list of third parties. And then, the third and the fourth are basically what I just kind of talked about, right? Which is how will I respond to a request to disclose third parties? Will I do it as the consumer's personal data? Will I do it as, any personal data? What are my business implications from those two types? And then maybe, I need to think about whether I could leverage something like a cookie policy, if that makes sense. And it becomes, sort of risk tolerance too. I will say as well, there are, providers out there that will allow you to, auto-populate lists of third parties. So maybe that would be helpful as well. But these are all considerations for you guys to kind of think about. And then Shelby mentioned GPC in Colorado, July 1, that's got to be recognized. And then we talked about data brokers. Okay, so let's move on. I promised this to somebody in the questions, the comparison charts. Listen, we're obviously just hitting high points of these laws to try to get you guys across the finish line here, identifying the requirements. But we've put out a lot of content if you want deeper dives into what has like entity or data level exemptions, those types of things. You probably have seen this on the blog before, and we've updated it recently for New Jersey and New Hampshire passing. So, they're there for you guys to use, and hopefully you find them useful. And then also our sensitive data chart. We just updated this last week to make sure we threw New Jersey in here. New Hampshire was, very kind of similar, but we threw New Jersey in as well. So hopefully those charts are kind of useful to you guys to try to drive compliance. All right, so let's move forward on the calendar and talk about October 2024. And I'll talk about Montana and with one slide, and I'll turn it back over to Shelby to talk about Connecticut Children's. Good news with Montana is, it follows the Connecticut Data Privacy Act. It's basically a clone bill. Senator Zolnikov's bill was intended to be to mirror the Connecticut law. There's one distinction I know that comes to my mind, which is on the scienter requirement with respect to children's data. It's just actual knowledge as opposed to actual knowledge or willful disregard as one in particular distinction. So I think, if you're coming up with your checklist of like Montana requirements, I think it's really a question of whether or not you're subject to an existing Connecticut variant. If you are, you're in good shape. I mean, you're not going to really have to do anything that I can think of different. If you are not already subject to Connecticut, then I think, or an Oregon-like law that is based off of Connecticut, then I think, you're going to have to be looking at it. And again, I think most likely you're taking a look at the children's privacy provisions to get across the finish line there. Okay, Shelby, you want to talk about Connecticut Children's?
Absolutely. So Connecticut's children's privacy law goes into effect on October 1st, 2024. So first step is determining whether this law applies. Unlike Connecticut's consumer privacy law, its children's privacy law does not have a processing or sale of personal data threshold. It applies to controllers that offer online products, services, or features to children in Connecticut. For the law to apply, the controller must have actual knowledge or willfully disregard that a consumer is a minor, which is under 18 under this law. The main obligation under Connecticut's children's privacy law is for controllers to use reasonable care to avoid any heightened risk of harm to minors. Under the law, a controller must complete a data protection assessment, and if the controller does so, there is a rebuttable presumption that the controller used reasonable care. So it's really important to meet this data protection assessment requirement. So what is heightened risk of harm? The law provides that processing that presents a reasonably foreseeable risk of unfair or deceptive treatment or any unlawful disparate impact on minors, any financial, physical, or reputational injury to minors, or physical or other intrusion upon solitude or seclusion, or private affairs or concerns of minors, if such intrusion would be offensive to a reasonable purpose. Those all qualify as a heightened risk of harm. So here we provide a list of when controllers cannot process a minor's personal data except with consent. So this includes controllers needing consent for targeted advertising, any sales of personal data, or profiling. Processing always needs to be reasonably necessary and for the disclosed purpose at the time of collection or for a compatible purpose. And the collection and processing should not be for longer than reasonably necessary to provide that product, service, or feature. In addition, companies cannot design a online product, service, or feature that would significantly increase, sustain, or extend the minor's use of that product, service, or feature. So I think of this a lot in terms of, online games that keep a player really engaged level after level. Connecticut requires a company to consider that increase and extension of use and whether consent needs to be needed in those circumstances. Then lastly, companies cannot collect precise geolocation data unless it's reasonably necessary to provide that product, service, or feature. And the company needs to provide a signal to the miner so that they know that they are having this information collected from them. So let's wrap up October here. First, do you collect personal data of Connecticut children under 18 years of age? If yes, do you obtain consent from children under 18 where you need to? Do you restrict processing of personal data to what is reasonably necessary and for the disclosed purpose? And have you completed a data protection assessment like I mentioned in the beginning? We all keep bringing this up with clients, this data protection impact assessment requirement, because although it's been common practice for companies operating in Europe subject to the GDPR for a long time, DPIAs are now becoming just as necessary to comply with US privacy requirements. So again, we're seeing these come up here in Connecticut's children's privacy law. So I'm going to let Dave take it away with January 2025.
Thanks, Shelby. And just to answer, there was one question. I'm trying to respond to questions as we go along here. So there's this question about consent. I think Shelby went over, but just to kind of hem it down with Connecticut. So these are the boxes, right? Under 13, parent consent. That's COPPA. None of that's changed. 13 to 17, the minor consents, right? The minor, the individual, not the parent, the minor consents. And then above 18, or 18 and above, I should say, that's Connecticut Data Privacy Act, right? So that's the opt-out regime. So hopefully that's so like these three buckets, right? And that's trying to at least, align how that law works. Okay, so hopefully that's helpful. January 2025, gotten past Christmas and holidays, and we are back into Delaware. Delaware has broken the law, which is to not have a privacy law go into effect on January 1st. We were getting very good at July 1st dates, which are wonderful, but Delaware has reverted to January 1. And actually, TK, I think this is yours. Am I not wrong? Have I jumped all on top of you here?
Yeah, no, I was going to let you run with it.
No, please.
Yeah, so January 2025, we have Delaware's law, the Delaware Personal Data Privacy Act, going into effect, which largely tracks Connecticut's law, apart from some notable differences that we'll point out. For example, like Colorado and Oregon, Delaware applies to nonprofits, but the law does exempt nonprofits that are dedicated exclusively to preventing and addressing insurance crime. Delaware also does not contain an entity level exemption for HIPAA-covered entities and business associates, although there are several data level exemptions for health data. They just don't exempt it at the entity level, unfortunately. As for consumer access requests, Delaware adds that consumers have a right to obtain a list of the categories of third parties to which the controller disclosed their data. This is somewhat similar to Oregon that Shelby spoke on earlier, although Oregon provides consumers with the right to obtain a list of the specific third parties. Again, similar to Oregon, Delaware law defines sensitive data to include status as transgender and non-binary. It also includes genetic and biometric data in its definition of sensitive data. And with respect to biometric data, the law's definition requires that you're using that data to actually identify a specific individual, not just that it is possible to use it for that. And as we kind of just discussed, like Connecticut, Delaware also contains a relatively high age requirement for controllers needing to obtain opt-in consent to process minors' personal data for sales and targeted advertising. So yeah, controller can't process for targeted advertising or sales without opt-in consent, where the controller has actual knowledge or willfully disregards that the consumer is at least 13 but younger than 18 years old, raising the more common age limit found in other state laws from under 16 to under 18. And now back to Dave to talk about his home state, New Jersey.
Yeah, thanks, TK. Sorry for butting in on Delaware, but So here's the problem with Jersey, and that's, TK said, that's from a guy who grew up in Jersey, so I can say that, right? Jersey is, and I should advance the slide, and we're short on time, so I'll kind of truncate this. They expanded the definition of sensitive data to include financial information. And it says financial information, which shall include a bunch of stuff, but it says financial information. So it really dunks up the works, right, about like collecting things like credit cards and all those types of things. So that's going to create some operational headaches. The exemptions, we've got a few of those there. It applies to nonprofits, no covered entity exemption, no FERPA exemption. A lot of these things we think are there, and we see in typical laws aren't there. And then they allow for rulemaking, but there's no time frame for rulemaking. So who knows when we're going to get rulemaking on New Jersey. The exemptions to sale, they're missing an important one with the exemption to sale. And it's got some other at least one requirement around the privacy policy and some stuff around children's as well. In interest of time, I'm just going to kind of move on. I mean, so we can get everything in front of you guys in the next 4 minutes. But New Jersey is going to require some thought. It is when we get to that part. Okay, TK, I think back over to you if I haven't screwed this up.
Yeah. Yeah, I'll go pretty quick. There's nothing too crazy here to write home about. Iowa's new law is one of the most business-friendly consumer data privacy laws passed to date. It's a lot like Utah. It doesn't provide for the right to correct. You don't have to get consent for sensitive data. You just have to provide notice and opportunity to opt out. New Hampshire just recently passed this year, and it largely tracks the pre-amended version of the Connecticut Data Privacy Act that was passed back in 2022. So you should be in good shape come January next year if you're complying with Connecticut for the most part. All right, yeah, other January 2025 considerations. The right to cure violations will expire in both Connecticut and Colorado. As such, you should consider reviewing your data practices to ensure compliance before the end of 2024. I think that's a typo in the slide. The requirements to recognize universal opt-out mechanisms will also be effective in Connecticut, New Hampshire, Montana, and Texas. Note that Texas does have that unique reciprocity approach where you're only required if you're already being required to recognize them in another state. If you're subject to the CCPA, you should consider reviewing and doing an annual update to your privacy policy. As for data brokers, those in California will need to re-register with the agency and report those metrics that I spoke about earlier by next January 31st. Texas and Oregon will also need to submit their renewal applications. In Oregon, this needs to be submitted at least 30 days before the expiration of your 2024 registration. Now to Dave for some extra considerations.
Yeah, thanks, TK. And I'll just, again, go through these quickly. I think they're kind of just, nice to know slides. So as you're driving compliance with these deadlines, I think it's worth taking a look at what the regulators have actually said they're looking to enforce. So Colorado has got some draft letters out, some template letters, I should say, about the things that they're focusing on. Not to say that's all they're focusing on, but like, hey, they're going to push it on their website, pay attention to it. And here they're talking about sensitive data and opt-out rights. Connecticut, you may have heard the Attorney General's office last week or the week before issued its report, its mandatory report under the CTDPA, and they talked about their priorities, in particular privacy policies, sensitive data, teens data, and data brokers as well. So I think looking at those reports and saying like, hey, if they're telling me I should button these things up, I probably should button these things up would be a smart move. And then a January 2025 checklist. Stuff we've all talked about, right? I mean, this compliance refresh around Colorado and Connecticut, I think is important. The rights to cure are going to expire. So let's make sure that we're actually up to date with those types of things. That financial data from New Jersey around the sensitive data collection, I think, those things are being important. And then the checklist type stuff, like do my links work, right? Going back, Connecticut talked about that, like links that went to nowhere or inoperable. Like we spend some time with clients doing like quality control stuff, right? And just making sure links work and things do it as they're supposed to do. And you'd be amazed at how many things you pick up on. All right, Shelby, do you want to kind of just take us through quickly on July 2025 then?
Yeah, absolutely. So to me, July 2025 feels forever away. but important to be thinking ahead always in privacy land. So if you are already tackling these obligations with compliance under other state privacy laws, keep these in mind as well. Tennessee will go into effect in July 2025. Like I mentioned earlier, Oregon's delayed effective date for nonprofits will hit in July 2025. And then, like other states, New Jersey will require companies to recognize universal opt-out mechanisms in July. So keep that in mind. And then over to you, Dave, to wrap us up.
Thanks for trucking. We're trying to hit the time. Listen, we're so far out at this point in time. Things are going to change substantially. You guys will hopefully be back with us again for a webinar to talk about December 2025, January 2026. But we've got Indiana. Remember, Indiana was one that passed its law pretty early last session. Well, it's not coming for a long time. And you have rights to cure, expire, and universal opt-out mechanisms as well. Hopefully this is useful to you. But again, come back to us in 3 months and we'll have a different timeline for these dates. With that, just some background materials for you, and we're over our time, but we have a lot of tracker maps. There's been a lot of questions about like this law, that law. We track all these laws and we have maps and pending bills. And I always call this the shameless plug portion of our webinar. If you're not already subscribed to Bite Back, there's a QR code there, and hopefully you'll think about subscribing to stay up to date. There's obviously, we're at 79 questions right now in the webinar, so there's obviously a lot of interest in this topic. Hey, listen, we appreciate your time, spending some time with us today. Apologize for being a minute over on our time here, but really do appreciate you. We look forward to seeing you on the next webinar. Thanks.